Greetings of the day. I am Megha Gupta, Assistant Professor in Babu Banarsi Das University. Today we will be studying the nature, sources of Muslim law. We will be covering two major topics. First is nature of Muslim law and second is sources of Muslim law. Under sources of Muslim law, we will be covering Quran, Sunnah, Ijma, Qiyas, judicial precedents, legislations, customs and equity and good conscience. Muslim law is known to be originated from the divine and not like man-made laws that are passed by the lawmakers and are governed by the principles of modern systems of law. Islam signifies submissions to the will of God and means purity, peace, salvation and obedience. Muslims believe that there is only one true God and that is Allah. In the case of Narantkat versus Prakkal, it was stated that there are two basic beliefs of Muslims. That is, first, the existence and oneness of God and second, the belief in the true Prophet Muhammad's mission. Under Islam, excellence consists only in deeds, and here worship of God means service of fellow men and the good of humanity. In Islam, the duties of a man are more important than his rights. It is said, God will not be merciful to who is not merciful to men, and all creation is the family of God. Nature of Muslim law can be divided into two, man-made laws and divine laws. Under sources of Muslim law, Quran, the holy book of Islam, is the primary and first source. The word Quran is derived from the Arabic word Quran and properly signifies the reading of which ought to be read. It has 114 surahs, also known as chapters, and 6,666 verses, ayat. It is the name of the holy book of the Muslims and contains direct revelations from God through Prophet. The direct manifest revelations consist of the communications which were made by the angel Gabriel. The Quran consists of communications of God. It is believed to be divine origin and has no earthly source. It is the first and original legislative code of Islam. It is the first and supreme authority. The second source in Muslim law is Sunnah, or also known as Hadith. The literal meaning of the word is the trodden path. It denotes some practice and precedence of the Prophet, whatever the Prophet said or did without reference to God, and this is treated as tradition. It is the second source of Muslim law. Prophet's words were treated as an authority because it is believed that even his sayings derived inspiration from Allah. According to Muslim law, there are two types of revelation. First is manifest, that is Zahir, and second is internal, that is Batin. Manifest or express revelations were the very words of Allah and came to the Prophet through the angel Gabriel. Such revelations became part of the Quran. On the other hand, the internal revelations were those which were the Prophet's words and did not come through Gabriel, but Allah inspired the ideas by his sayings. Traditions therefore differ from Quran in the sense that Quran consists of the very words of God, whereas Sunnah is the language of the Prophet. Sunnahs can be divided into three. The first is Sunnatul Qawl, also known as words which are spoken. Second is Sunnatul Fi'l, which is the conduct of the Prophet. And the third is Sunnatul Tahrir, which is the silence, that is the matters in which the Prophet was silent. The third source of Muslim law is the Ijma. Those persons who had knowledge of law are called jurists. When Quran and traditions cannot supply any rule of law for a fresh problem, the jurists unanimously give their common opinion or a unanimous decision, and it became termed as an ijma. Not each and every Muslim was competent to participate in the formation of ijma, but only the jurists could take part in it. The ijmas are of three kinds. First is ijma of companions, that these companions were the companions of the Prophet, and these ijmas are considered the most authoritative. Second is the ijma of the jurists. These are unanimous decisions of the jurists. Third is ijma of the people or the masses, and here the majority opinion is followed. The fourth source of Muslim law is the Qiyas. It is derived from the word yakish, which means beat together. It means measurement, accord and equality. The Qiyas is a process of deduction which helps in discovering law and not to establish a new law. Its main function is to extend the law of the text to cases which do not fall within the purview of the text. So, certain conditions must be followed in order for a qiyas to be valid. The first condition is that it should not be specified to certain texts or particular situations, but should be applied to those texts which can be extended. Second is the analogy deduced should not be inconsistent with the diktats of the Quran or the Sunnah. Third is the condition should be applied to discover a point of law and not to determine the meanings of the word used in the text. The fourth condition is it should not bring a change in the law embodied. If there is a conflict between two deductions, a jurist is free to accept any one. The fifth source of Muslim law is customs. For a custom to be valid, it must be continuous, it must not be contradictory to the Quran or Sunnah, and it must apply to everyone who follows Islam. The sixth source of Muslim law is legislation. Muslim law has suffered greatly as a result of lack of effective regulatory frameworks. There were just a few acts which governed the area. However, after the independence of 1947, there has been great progress in the area and Muslim law has been codified to a great extent. The seventh source of Muslim law is precedents. Judges emphasize the law when they investigate specific cases. These rulings appear as precedents for future cases, and the lower courts have to follow the judgments of the upper courts in the areas which have been dealt by the upper courts. The eighth and last source of Muslim law is equity, justice and good conscience. One of the origins of Muslim law is the idea of fairness, justice, equity and excellent conscience. Istihsan means liberal construction or juristic choice, or what we now refer to as equity law, and these are the doctrines which govern the Islamic world. To respond to various conditions in India, a number of Muslim provinces have been transformed. Although the British originated this notion of equity, it has been adopted by various Muslim schools of law.